Good morning to all. Today we will continue with the new topic like fundamental rights. So far what we done it, the first class we discussed about introduction, then after introduction some strategy. Then after that strategy, we start with Article 1 to 4. So we discuss about Article 1 to 4 in an elaborate manner. Then in a narrow manner, we discuss about Article 5 to 8, that is citizenship and related to bills, etc. Then fifth, we discuss about preamble yesterday. In the meantime, we discuss about NRC also here. Okay. So far the discussion happened like this, and the way how we discuss with the help of the preamble and based on other ideology, we are having some basic about the objective of the constitution, if you want to say very clearly. So the objective of the constitution, that is the main purpose in order to learn about the knowledge of preamble. The objectives are very clearly saying that we need to take care of the welfare and well-being. So everywhere these things are very necessary. The welfare and well-being is a major objective of constitution. Okay. So how I am going to provide this welfare and well-being? So as a government of India, as a parliament which is having its own constitution, it's also striving towards in order to achieve this welfare and well-being. That is an objective of the constitution through various means, but we simply discuss about preamble, because through preamble only the constitution is also deriving its own source. Preamble is helping to people, that is in judicial services, can able to do some idea in the name of interpretation. So the interpretation part will also get its own meaning with the help of preamble. The welfare and well-being is an ideology, it's also getting its own meaning with the help of preamble, that is an objective of the constitution. So in two ways preamble is giving some meaning to the constitution. One is the constitution derives its authority from preamble. Second part is constitution or the sole interpretation of the constitution also can able to done with the help of preamble. So this is the way we discuss something about preamble. But other than this, we already discussed there is a philosophy. So this philosophical part we need to discuss a little bit. That philosophy of the constitution is based on two ideology, fundamental rights and directive principles of state policy. So while discussing about this philosophy, the fundamental right and directive principles of state policy is acting like a philosophy to the constitution. Already the constitution derives its authority from preamble. So if you are connecting the preamble with the fundamental right in DPSP, we can able to completely get the resource as well as the objective as well as the philosophy of the Constitution of India. Because our constitution is providing welfare, our constitution is providing objective. So this is the most important thing. So in that we are going to discuss about the methodology of philosophy. So now my question is that fundamental right is considered as a philosophical part along with the directive principles. So what the fundamental rights are going to give? These fundamental rights are considered as an essential right in order to protect the right and liberties of the people, because there may be always a possibility of encroachment from people's side as well as from the government side. Whoever is having power, the power people definitely will try to encroach the other people's authority and the domain. So this is the problem generally happening in this world. If I am having a power, I may misuse. We can have the best example according to Artha Sastra, Kautilya or Chanakya or Vishnugupta. You can say any word. He simply proposed some kind of ideology. The power corrupts power. And based on this power corrupts power, he also mentioned that who are the people who is trying to utilize the financial activity, definitely they will try to lick it a little bit. So this is a kind of corruption related ideology. So first one is power, and second one is the financial activity. Whoever is handling finance, they will try to keep something for themselves. So on the basis of this ideology, if you want to continue that, whoever is utilizing the concept of power and using the concept of power, there may be a possibility of misusing those power in favor of themselves. So in order to avoid how the way the fundamental rights are acting like an essential component to the people, how the way the fundamental rights are helping people to having their own rights and liberty in order to avoid any kind of encroachment from other end of. So for this purpose, I need to have this fundamental right. So fundamental rights are the essential part. Fundamental rights are the basic one. The fundamental rights are the one automatically once submitted to the vote of the parliament. So there may be a possibility that through the voting procedure or through the normal procedure of the parliament cannot able to curtail the rights of the fundamental rights or the rights of the people. So this is the way we are considering fundamental rights are the very fundamental while comparing with all other rights. It's a constitutional right. The way what we are going to discuss in part 3 and article 12 to 35 is simply giving some kind of meaning to how the way this right is acting like an essential right. These are the essential right in order to strengthen my own right and liberty. So based on that, I am also having certain concern that and what way I can able to use this right. These are the right, basic right and essential right to strengthen my personal liberty as well as my equality as well as right. But while using that, is there any restriction I am having? While comparing with the United States of America, there the fundamental rights are absolute in nature. But while comparing with India, our fundamental rights are not absolute. We are having some reasonable restriction. Even though these are the essential right to strengthen my right and liberty, but at the same time, my right and liberty is if against the collective interest of the society as well as people, it need to be restricted. Here only the American fundamental rights differs from the Indian fundamental right. Here we are giving much importance to collective interest of the nation. In America, they are giving much importance to the individual interest. Individualistic interests are more than collective interest. So while discussing with the ideology of fundamental right, these fundamental rights is guaranteeing and warranting certain essential things to the people of India within its ambit. But that ambit, even though it is coming under the category of article 12 to 35, but there will be a reasonable restriction. The government can put certain things and certain things weren't applicable to foreigners. In this way, some kind of restriction we are putting. One is the government, wherever they are feeling that the citizen is utilizing them in the essential part in an extraordinary manner, but that extraordinary manner is going to affect the other common people and the law and order and public order or any kind of relation with the neighborhood country or something like that, then immediately the fundamental right of individual will be curtailed by the Parliament of India. Parliament can able to make laws regarding fundamental rights because fundamental rights it's a legally enforceable. Fundamental rights are the justiciable part, but at the same time Parliament can also able to make some kind of laws in order to stop fundamental rights. We can have some example that article right to property was once upon a time the basic fundamental right, but when the article the right to property is directly conflicting with the ideology of nationalization, immediately the founding fathers decided that, and the later part the government decided that, parliamentarian decided that, if you want to say exactly, they removed the area of the right to property from fundamental right and simply inserted into the idea of a legal right in 300A from 19. So these are the best example we can see. But when I am altering certain things, I need to keep the most important provision. An amendment inside fundamental right should not violate the basic principles of the basic structure of the Constitution. Even though the basic structure is the concept is not defined properly, The basic structure is an ideology, is having some kind of meaning to the people. But at the same time, the basic structure is the one always defined by the court of law, and it will differ from one case to another case. The court of law will decide about the courses, how the way it is going to define the concept of basic structure. Without altering the basic structure, if the government is trying to enforce certain things upon fundamental right in the name of reasonable restrictions, or the government is altering certain fundamental right, adding certain fundamental right, removing certain fundamental right, the only one thing the court will see whether it is trying to violate the basic structure or not. If it is not, then there is no issue. Let the fundamental right can remain, or let the fundamental right can be a legal right. We can't able to ask any question, because I already told you that American fundamental rights are absolute in nature, Indian fundamental rights are not absolute in nature. But if you are seeing a very general ideology, Indian fundamental right or the fundamental right of our land is not sacrosanct. That is why I am saying that whenever you are feeling uncomfortable with a certain fundamental right, the parliament is having ultimate authority to realign those things. It is not sacrosanct. In religious books, if something is written, then other person cannot able to alter or even adding a comma or full stop inside the holy books. The same way we can't able to say that fundamental rights also a kind of sacrosanct ideology, a holy things. So no one having the authority to alter or change or delete or something like that. If these fundamental rights are having a conflict with the government, or if these fundamental rights are having a conflict with the individuals, then definitely we can able to do something in the name of managing fundamental right or altering fundamental right or other various ideas. So, the most important part we will discussing about fundamental right, part 3 and article 12 to 35. The fundamental rights are the basic one. The fundamental rights is enforcing the ideology, basic philosophy of the Indian Constitution along with the directive principles. That is why it is considered as fundamental right. It is giving some kind of basic right to the people. Fundamental right is giving the essential part to the people. Fundamental right is a very basic fundamental right. So we are saying that these fundamental rights are the very necessary concept and essential concept. If your country is having a democratical values and ethos, those democratical values and ethos can able to enshrine with the help of fundamental right. So these are the most important thing. That is why it is called as a fundamental right. By the people, of the people, for the people. So while discussing about the by and for and of, how can I can say that this government is having a democratical principle? The way I am handling the fundamental right, the way the fundamental rights in a land is existing, and the way the fundamental rights are available to the people in an extraordinary manner. So based on that, the availability of fundamental right and the application of fundamental right, on the basis of this, I can say that this country is having a democratic values and ethos, and those democratic values and ethos, in a simple manner, I can say that the fundamental rights and directive principle, on the basis of this democratic values and ethos, I can say that this is the philosophical part of Indian Constitution. So that is why it is called as the essential right. But while discussing further, these are the fundamental right. It is not applicable to all people, and these are the fundamental rights are the basic one, and these fundamental rights are always considered as an essential part, and it is freely available to all citizens, and certain fundamental rights also available to foreigners also. And this is the way I am going to make a distinction, that these fundamental rights are absolute, not in Indian cases, but while doing so, the fundamental right as a concept can able to elaborate with the help of one particular concept of rule of law. What the fundamental right trying to enforce in a land? The main purpose of the fundamental right is trying to enforce inside a land in a simple manner, if you want to say that, the right to equality. So I want to bring equality irrespective of race, caste, gender and other various purpose. I want to strengthen the ideology of equality, but how I am going to bring the equality? I can simply say that if there is a rule of law existing inside a society, in those society, we can clearly say that the principles of fundamental rights are in a proper manner and in a uniform manner, in a very essential manner existing inside a society, because the rule of law is having three important features. Based on the three important features, we can say that this rule of law is having a principle of very essential part of the Constitution. If you are seeing that the first part in rule of law, a very simple concept, if wherever the place the ideology of arbitrary action is existing, there you can't able to say that the rule of law is existing. So inside a land, if the people are existing, means they should have some kind of sovereignty as an individual. They should have some kind of liberty as an individual. They should have some kind of equality as an individual. If I am suppressing some people on the basis of my suppression, my pressure, someone is sitting inside the class, that is not a free class, because by force you are sitting there. There is no rule of law is existing inside the class. Whenever you want to leave, whenever you want to come, you can come. You are having the complete independence. Whenever you want to go somewhere inside this land, no one is going to stop you, because you are not under the arbitrary action of anyone. You are completely free. So this is the way the fundamental rights as a basic principles and essential principles, we are saying that wherever the rule of law is existing, there you can able to see the ideology of fundamental right. And the first important point, how rule of law can able to exist according to Daisy. A.C. Daisy, he was a popular Western philosopher who gave an ideology of rule of law on the basis of the first principle, the absence of arbitrary action. Where the absence of arbitrary actions are existing, there the rule of law will exist. And second one, if you are discussing about the rule of law, the equal protection. So I am not going to give some kind of equality to everyone here, because equality to everyone is a kind of negative concept. But if I want to preserve, if I want to protect each and everyone inside the class, then I can able to say that the rule of law is existing here, because I am treating the first person and the last person in a very equal manner. I am protecting them in a very equal manner. So that was the major ideology. The equal protection is the very most important thing. Wherever the government is giving the protection in a very equal manner, irrespective of the race, caste, religions, gender and descent and place of birth, there the ideology of rule of law will exist. And the most important thing, that is the only part missing in India. In India, the absence of arbitrary action and equal protection is properly existing. But the third part only exists in America, but not in India. But still, all the country like India and America, both are having the rule of law and both are having the essential part of fundamental right. But Indian fundamental right is having only first two conditions, and the third condition is missing. Here, the source of Constitution. Constitution is an essential part. It derives its authority the way it is providing some kind of basic equality and basic rights to the people. So the way the source of constitutionalism and the source of constitution is existing inside a society, based on that we can able to say that the collective ideologies and individualism is existing. So the Constitution is a source, or the law is a source. If there is an ideology that the Constitution is properly written inside the country, and this Constitution is acting like a source to the people, one side, and the rule of law, based on that, the courts are also keep on giving various verdict, because in America, judicial supremacy is more, but in India, parliamentary sovereignty as well as judicial supremacy is combinedly existing here. So we won't say judiciary can only make laws. Parliament is the essential body, will make law. Parliament sovereignty, but judiciary is the one which keep on checking that how the way the parliament is functioning, how the way the parliament is making. So in this manner only, in India, collectivism is more, because once constitution come out, through the constitution we can say that according to preamble, we the people of India are the real power, we all are supreme, so we are the one who most important people. So through this we feeling, I can able to say that the collectivism is more powerful and more essential part than individualism in India. In USA, the individualistic ideologies are more interest, because the court of law is an ultimate authority to make some kind of laws through its verdict. In India, parliament is an ultimate authority to make this law. Through this parliament, we can have constitution. Through this constitution, we the people are supreme. So in this way manner, in this way only, we are saying that we feeling that is collectivism is the most essential part in rule of law inside India, but in USA, individualism is more important protection. So on the basis of these three important ideology, the collectivism versus individualism, we can say that the rule of law is existing. Wherever these kind of principles are existing, there you can say that the fundamental right and right to equality is properly existing in our country. Okay. So this is just a beginning, just an introduction I am saying that. So I am just summarizing the entire thing before going to enter into the main part. The fundamental rights are essential one. In what way it is essential? The fundamental right is trying to give your own right and liberty in a proper manner. So the way it want to provide the essential part to a human being, the liberty and right, based on that we are calling this is the very most important fundamental right. The way this essential part, liberty and right, the moment it get diluted and people will lose their own individualistic characteristics, the people will become a kind of slave kind of actions they need to practice in their life. So based on that, I am saying that the most important part, that is the rule of, fundamental right is a very essential part. So while discussing about this fundamental right, I am saying that fundamental rights are more important ideology, and at the same time, fundamental rights are not sacrosanct. Fundamental rights are not holy thing, because in fundamental right, if I am feeling that something is wrong and something is not suit for my own people, so I can able to change those fundamental right, because if it is a sacrosanct like holy scripture, you can't able to alter even comma and full stop, then automatically the law of blasphemy will against you, so people will take action against you. But in here, best example, when Indira Gandhi felt right to property is not an essential right for the people, which is directly conflicting with an ideology of nationalization, then immediately Indira Gandhi deleted that provision and they inserted later inside as a basic legal right. So once upon a time it was a fundamental right. Later part, when nationalization became a prominent area, then they simply converted into a basic legal right. So it was an ideology. Once upon a time right to property was existing in 19, then it moved into 300A as an ordinary legal right only. Based on that, we can have a conclusion that if you want to alter, even though the fundamental rights are the essential part, if you want to do alteration, only one thing the court of law will check it, is there any violation for the principles of basic structure or not? If there is no violation for the principle of basic structure, then there is no issue with the fundamental rights alteration. The parliament can able to make alteration, amendment inside fundamental right also without disturbing the idea of basic structure. So if you are going to continue about the features of fundamental right, these are the core fundamental principle, these are the essential fundamental principle, on the basis of liberty and equality and right. So based on that, we can say that we are living in a democratical country which is having the values and ethos, the democratical values and ethos. Through these democratical values and ethos, we can proudly say that we are living in a democratical country. So while discussing about the values and ethos, I am saying that there is a philosophical part for the Indian Constitution. That philosophical part is having fundamental right and DPSP. So these philosophical fundamental right only right now we are discussing. Later part we will discuss about DPSP. And this philosophical part like fundamental right is a very essential part because it is having some very most important feature that the fundamental rights are there, and this fundamental right is not in absolute term. It always the government will use the ideology of reasonable restriction upon, even though these are the essential part, but these essential part may harm the idea of collectivism. So in order to avoid those things, the government is using the ideology of restriction. But in America, collectivism is not more important. Individualism and individualistic ideologies and principles are very, very necessary. That is why in America, fundamental rights are not within quotation of reasonable restriction. They are completely, absolutely absolute, if you want to say that. Government cannot be able to stop the right of individuals. Individual freedom is more in America, so their fundamental rights are absolute. Indian fundamental rights are not absolute the way it is presented to the people. So while discussing about the basic structure, no one can able to define except the court of law. Constitution, we don't have any definition in order to define rule of basic structure of the Constitution. Only the code with the ideology of the doctrine of interpretation, the doctrine of pith and substance, they may use the ideology of this particular basic structure. This is a very common ideology. While discussing further, I said wherever the ideology of rule of law is existing, based on that I can able to say that the essential part of the Constitution, that is fundamental right, is also freely existing. Then I need to define what is rule of law. My foremost important objective here to strengthen the democratical values and ethos. If I want to strengthen the democratical values and ethos, I need to provide an essential part to the people. Based on that only, I can able to say that the values and ethos is properly existing inside the society. Based on these values and ethos, people are living happily. And in this value, I am saying that the right and liberty is a very common thing as a democratical value I can able to give to the people. But while giving to you, I am having some problem in the name of equality. I may give some people, I may give 50% to some people, 80% to some people, 100% to another people. There may be a bias on the basis of my own religion, my own race, my own caste, my own ideology. So in order to avoid these things, people are saying that wherever the rule of law is existing, there the equality will be properly present in the society. Based on that, we can say that the essential part of liberty as well as the right or the ideology will be properly given and properly exist in the society. In that society, definitely will have the basic essential principles of fundamental right. While doing, I am having rule of law. How I am going to derive rule of law? I am not going to derive rule of law on my own way. The rule of law, according to A.C. Dacey, he gave a very popular definition for that one. Wherever the absence of arbitrary action is existing, people are completely attaining their liberty and freedom, there the rule of law will exist. Wherever the rule of law will exist, people will have the freedom and liberty, no arbitrary action from the government or any individual or any big people. So there the rule of law is exist. And wherever the rule of law will exist, the government will protect equally all people. The equal protection will be given to each and everyone, and rich and poor will get proper protection. And finally, the sources for the Constitution, whether in judiciary is a kind of source for the Constitution in America, the way they are giving verdict after verdict, that is why in America, judiciary is supreme. But in India, we can't be able to use this concept. In India, parliament is having ultimate authority, judiciary is also having ultimate authority, but the way parliament is having some kind of constitution, based on this constitution, the constitution is saying that we the people of India is supreme, not I is supreme in India. I feeling is existing in America, we feeling is existing in India. So through this manner, I can able to prove ultimately individualism versus collectivism. Where the collectivism is existing, there the fundamental rights will be exist. Where the individualism is existing, the individualist interest will be more. This is the basic difference between Indian fundamental right and American fundamental right. American fundamental right is an absolute, so it is giving freedom to individual. Indian fundamental rights are not absolute, it only give importance to the interest of the collection, the collective interest, not individual interest. So this part is a basic difference. It is not existing in India. India only collective interest, but according to Daisy, individualism is more important. So I can say arbitrary action, equal protection. Based on the two principles, rule of law is existing in America, arbitrary action, equal protection, and individualism against collectivism. So they are having absolute right to equality, and absolute rule of law is existing in America. So these are the very common and some basic and essential things while discussing about fundamental right. Any doubt you are having? Good. So just note it down. Fundamental rights. Fundamental rights. Fundamental rights are considered essential to protect the rights and liberties, essential to protect the rights and liberties of the people. Fundamental rights are considered essential to protect the rights and liberties of the people against encroachment by government. They are made to control the powers of the government, legislature, as well as executives, the executive. They are essential for the preservation of public and private rights. Okay. Next. The inclusion of fundamental right in the Constitution act as a reminder to the government, in power. the reminder to the government in power that certain liberties assured to the people, certain liberties assured to the people by the Constitution are to be respected. By the Constitution are to be respected. Next, the object behind the inclusion of fundamental right. The object behind the inclusion of fundamental rights in the Constitution, the object behind the inclusion of fundamental right in the Constitution is to establish a government of law and a governmental system, a government of law and a governmental system where the majority does not oppress the minority, majority does not oppress the minority. Next point, fundamental rights are not given to people, fundamental rights are not given to people in an absolute manner. Fundamental rights are not given to people in an absolute manner, because unrestricted rights to a citizen, can destroy the right of others, Full stop and continue. Absolute liberty to an individual, can destroy the society, Okay. Next point. A balance of achievement, a balance of interest is achieved in the Constitution. A balance of interest is achieved in the Constitution by enumerating. A balance of interest is achieved in the Constitution by enumerating. Enumerating the fundamental rights and by setting limits within which they can be curtailed. They can be curtailed. C-U-R-T-A-I-L-E-D. They can be curtailed. So, the Constitution permits reasonable restrictions. The Constitution permits reasonable restriction to be imposed on, the Constitution permits the reasonable restrictions to be imposed on individuals' liberties, underline, imposed on individuals' liberties in the larger interest of society. In the larger interest of society. Okay. Till now, any doubt you want to ask? Basic fundamental things. Okay. The next one. We will start with Article 12, first one. We are entering into fundamental right. I said at the beginning, your right and liberties is properly enforced on you, enshrined on you. Then you all are feeling that you are feeling more comfortable. If someone is tried to restrict your right, then automatically you will feel uncomfortable. Normally this is the common tendency of every human being. That when you are walking and someone is interfering, then automatically people will get irritated, because now the things are there. So this is a kind of feeling, liberty is a kind of feeling, and the right is a kind of authority or the kind of insertion inside your life in order to lead your life in a very, very free and fair manner. So whenever this feeling and whenever those rights get affected, then people automatically will become irritated and they will try to they try to break those situations. It's a normal tendency. So this is the most important idea while discussing about. I'm feeling that the moment my right get affected, then to whom I need to approach? I'm saying that fundamental rights are essential right. Fundamental rights are basic right. Through this essential and basic rights only, I am enforcing starting from Article 12 to 35 as the very most important article in order to make people more comfortable inside the society. That is why we are calling this is the very fundamental and basic right. So the moment my fundamental right get affected, I need to approach a body. In India, that body is considered as judiciary. Judiciary. In the first class, we discussed about that it's having two important things. The first and foremost important ideology the judiciary is having in the name of the interpretation of Constitution. So whatever the doubt you are having, you are asking. Still, if I am not here, in home you are there, you just take the book and read twice, and the book will give some kind of interpretation to the meaning of what is the rule of law, if you are not understanding. Read it third time, fourth time, fifth time, then fifth time you will become master of rule of law. So that is the most essential part. Okay, so the judiciary is acting like an interpreter. Well and good. And the foremost important thing, 3 years before UPSC asked this question in 2016-17, that judiciary is also acting like a guardian to the Indian Constitution. So the way it is guarding the constitution in a well protected manner, and based on that, no one from outside can able to come. Who is that no one from outside? That is a government, that is an executive, that is an legislative, while making laws, while implementing laws, there may be a possibility they may encroach the essential part of the basic, they may encroach the essential part of the basic features. So here I am having some kind of reservation. My right should not get affected, but now my right get affected. So to whom I need to go? Who is the guardian to the constitution? Supreme Court of India. So I am giving some kind of essential things to the people, that if your right get affected, normally if it is a legal right, go to the nearest station, file a complaint, then go to the district court, then go to the high court, then come to the Supreme Court of India. But I am making this not an ordinary right, this is an extraordinary right, this is the basic right, and this is an essential right. When your essential right get affected, you are not approaching the lowest person, you are coming directly to the Supreme Court of India, filing a litigation. Through this, you are trying to access your own right. That is the most important part we are discussing here. So that is a very essential part we are discussing here. The Constitution is giving some freedom to you, that if your fundamental rights get affected, you can directly approach to the court. So that is the most important thing. So this is the very most important thing. For the violation of your own fundamental right, you are approaching the Supreme Court of India directly in respect of fundamental rights. Okay, good. So what the essential part here? If once your fundamental rights get affected, you are directly approaching the Supreme Court of India. You are not seeing any lowest person, you are seeing the highest person. Like that manner, it is giving some importance to individual, because guardian is the most important position we are giving to Supreme Court. Supreme Court is guarding not only the constitution of the entire India, the Supreme Court is also guarding the rights of individual. Through this manner, the Supreme Court is an ultimate authority. Suppose while doing so, the Supreme Court is committing some mistake, possibilities are there, all are human being only, then immediately the court will correct its own mistakes by the principles of judicial review. The court will correct its own mistakes by the process of judicial review. So the essential part is that, for example, your fundamental rights get violated, so you are approaching a High Court also as well as Supreme Court also. You can approach in both ways. If the High Court is very near, you go to High Court. If the Supreme Court you can directly want, you can go to Supreme Court. But if you are not satisfied, there are a lot of appeals also there, from a single judge bench to a multi-member judge bench and constitutional bench. So that is the most important thing. Judiciary is not only acting like a guardian for the people against the government and executive and legislative. Judiciary is also guardian to judiciary itself. When the judiciary is committing some mistake, judiciary can able to correct themselves with the help of judicial review. Judiciary can able to correct themselves with the help of judicial activism. Judiciary can correct themselves with the help of judicial overreach and outreach. But the process is that mainly, according to the procedure established by law, through the judicial review, judiciary will correct its own mistake. So that is an ideology we are discussing. Okay, good. So I am saying that someone violated my fundamental right. I am approaching the court. Who are those people? Maybe individual. We are legally confined, I lock the door, I am not allowing you to go out of the door until my class get over, suppose. But there is an emergency, you want to go, your fundamental right here restricted. So you can able to approach the court directly. Against whom? As an individual, you are complaining against me. But the government and MCD is locking the door. So you are appealing before the Court of India against the MCD and against the state government and against the Parliament of India. So that is the most important part we need to define. Fundamental rights are there. It is properly guarded by the Supreme Court of India. Who are the one who is violating? You and me are individual. I can able to violate your fundamental right. You can able to violate my fundamental right. Our fundamental right maybe collectively can be violated by the parliament and central government, legislature and state government and some public sector undertakings, some kind of companies, etc., etc. All the things we need to have a clarification. For that only we are having Article 12. Article 12 defines the ideology of state. It defines the ideology of state. We will discussing about judicial process. If according to the rules and regulation, we are doing all kind of activity, that is review, judicial review. Some process has done, verdict has given, so now I am checking only revisiting that verdict according to the law established by, procedure established by, that is judicial review. But in some case, procedure is saying something. I am understanding the procedure. According to that, the verdict came into. But I want to go beyond that one. That is called as judicial activism. The example we can say that in 2000 around the Court of India, Delhi, gave a verdict within 6 months. Every commercial vehicle in Delhi need to convert it into diesel and petrol into CNG. Where it is written? In our constitution. Where it is written in our penal code? Nowhere. But still the court received. The court gave an order. So what is the purpose? There is no procedure established by law inside India, inside penal code, inside constitution. But the due processor of law is saying that Delhi is under severe pollution. We want to save Delhiite people. So what I am doing that, make it compulsory that all the commercial vehicles first need to transfer from CNG to petrol, from petrol diesel to CNG. So it is a compulsion, a kind of activism the government is using. But activism in simple manner, for a layman's point of view, if you want to say that if the government is going through, the court is going through the procedure established by law, that is judicial review, and if the government is going beyond the procedure established by law, so court is going beyond the procedure established by law, that is called as judicial activism, and the court is completely violating, completely acting beyond its jurisdiction to encroach others people's activity, that is called as judicial outreach. So this is the most important distinction. Judicial review, judicial activism, judicial outreach. Review within procedure established by law. Activism beyond procedure, that is due process of law. And judicial outreach, in most of the cases in judicial outreach, they will find that is wrong only. Judiciary will also do some kind of mistake. That mistake we will simply quote it in the name of judicial outreach, judicial overactivism or judicial overreach. These are the very common ideology according to Article 32 and 226. These are the very essential part. The judicial reviews and ideology of Supreme Court will be through 332 and High Court they will do via 226. Okay. Now coming back, we have to write about Article 12. First point, fundamental right, we are entering into Article 12, put a hyphen and write the definition of state. The definition of state. The term state includes the term state includes the government and the Parliament of India, second, the government and the state legislative assembly, third, all local and other authorities, all local and other authorities within the territory of India, within the territory of India, and next, all local and other authorities, all local and other authorities under the control of government, all local and other authorities under the control of government and last one, any public sector undertakings, any public sector undertakings and any other authority includes by the Parliament of India, any other authority includes by the Parliament of India in future, the Parliament of India in future is all coming under the category of state, is all coming under the category of state. Second point, the meaning of the term authority, the meaning of the term TRM, term authority, the meaning of the term authority in part 3 of the Constitution. The meaning of the term authority in part PRT, part 3 of the Constitution. Part 3 of the Constitution. Put a hyphen and write. Authority means the power to make rules. Authority means the power to make rules, orders, legal orders, orders, regulations, bylaws, BYELAWS, bylaws, notification, etc., notification, etc., which have the force of law, and power, to enforce those laws. Power to enforce those laws. Okay. Any doubt while defining Article 12? 12 is talking about what is state. State means central government and parliament, including president, state government and legislative assembly, including governor, local authorities inside the territory of India, and local authorities and other authorities under the government of India. Then finally PSUs or any other authority in future, the parliament may include, all are coming into the category of state. What is the difference between second and third and fourth point? The third and fourth point, local authorities within a territory and within a government, So we'll discussing about the local authority. There are so many layers of local authorities are there that everyone knows that after 73rd and 74th. We are having a clear understanding. Article 12 as the media was offline here. Okay. Okay. So we'll discussing about Article 12. Article 12 is defining the concept of state. So while defining the concept of state, the first condition is state means, the first condition is parliament and central government. Then second, state government and legislature. Third point, local government within the territory. Fourth point, local government within a government of India. And fifth point, PSUs, public sector undertakings. And any other authority in future, any other organization in future, if the parliament may feels that we need to add and bring into the category of local authority, so all these things will come into the category of the definition of states. Okay, so parliament, assembly, as well as local authority. So while defining the local authority, I give to local authority inside the territory of India. Territory means we know very well state, union territory and acquired territory. Everywhere the territory will come. But while going to the second category, the local authority inside the government. Because if we are seeing that the local authority, we are having some kind of issues. Panchayat Raj will be in a general manner on the basis of at the urban level and rural level. And rural level, the basic unit of the Panchayat is Grama Sabha, and urban level, we can say that the Metropolitan Corporation, district development planning, district planning committees, these are the ideologies are existing. But apart from that, there are some ideology also existing directly under the government of India in the name of Panchayat Raj institution. The best example, the Cantonment Board, Agra Cant. So many various cants are existing. Who will appoint the personality? They are also having a local government inside cantonment. So you are having a municipality in one area, and that is directly under the control of military. Military also should have a local government. So further, the government, according to 1921 Act, Military Municipal Act, the government is appointing certain people inside the cantonment board and other area. So through the notification of the governor, the state government will appoint and create a notification and notified area board. Like this manner, there are various boards also appointed by the government of India that is coming under this category. Okay, good. Next one, Article 13. So the next idea is Article 13. Put a hyphen and write laws inconsistent with fundamental rights. Laws inconsistent with fundamental rights. Article 13 is discussing about laws inconsistent with fundamental right. First one, Article 13(1). What is the fifth point? That is the public sector undertaking and other any body in future, if the government may add in the name of state. Public sector undertakings are there, a SAIL, Life Insurance Corporation, various government bodies are there. There your fundamental right also may get. You are the employee of ONGC and ONGC is not giving basic fundamental rights to you. Then you can also be able to approach against ONGC in court, because ONGC is also coming under the definition of state. LIC is also coming under the definition of state. SAIL, Steel Authority of India. Like this manner, we are having various PSUs, public sector undertaking. There, the government is having 51% shareholding. Those kind of companies under the control of government, these are all called as corporations of government. These are public sector undertakings. Okay, good. Write it down. The law inconsistent with the fundamental rights is Article 13. In the first point, Article 13(1) declares that Article 13(1) within bracket 1, 13(1) declares that all laws, 13.1 declares that all laws in force in the territory, all laws in force in the territory of India immediately before, all laws in force in the territory of India immediately before the commencement of the Constitution, immediately before the commencement of the Constitution shall be void, shall be void, VOID, not eligible, cancelled, nullified, shall be void, VOID, to the extent to the extent to which they are inconsistent with the provisions of PROVISIONS, the provisions of Part 3 of the Constitution, Part PART, Part 3 of the Constitution. So now, I think you can easily understand about the ideology of 13.1. Any law inconsistent with Article 13 is considered as null and void, not eligible in India. There are some post-constitutional laws also there, post-independence laws and pre-constitutional, pre-independence law. So the day we adopted Constitution on 26th November 1949, before that, what are the laws are existing in India? These are all pre-constitutional law. On 26th November and 26th January 1950, what other things that came into exist? These are all a post-constitutional law. Suppose we are having some provision in India that some post-constitutional law also, constitution and constitutional provisions also existing, and pre-constitution and those provisions also existing. When there is a conflict between the pre-independence based law and post-independence based law, and conflict is happening between each other, then the post-independence law only will prevail and the pre-independence law will go down. This is an ideology they are talking that. One idea. But I am seeing that one law has created in 1861 and it is violating, it is creating conflict with the fundamental right or any law inside India. But I am seeing that only one provisions of those law, not the entire law is conflicting. Only section 35A of one particular part of 1861 Act is conflicting with the fundamental right 14. It is not necessary. I need to remove all the 35. We can able to remove only the 35 first section, second, third, fourth will remain in the same way. This is also possible. This is the principle is considered as doctrine of eclipse. Doctrine of eclipse. So in eclipse what we are seeing, we are trying to avoid, okay, the sun, moon, earth, anything which is coming between earth, when automatically the other object will be disappear, that is eclipse. Moon is here, then if the earth is here, if the moon comes, then you can't able to see the other part of the sun. Sun is here and earth is here in the middle, moon is and sun is here, some other object is coming. So this part is eclipse. Generally we will say that you can't able to see either sun or either moon when the other part is coming in the middle of the same way. It is not necessary all the time a law which is inconsistent with the post-independence law will be considered as null and void and deleted from the Constitution. The part which is considering a conflicting area, those part only we will keep remove it, and remaining sections will be remain in the same manner. This principle of deleting only a contradicting part is considered as doctrine of eclipse. So you are hiding only controversial part, not the entire Article 13, not entire 18, not entire 19, only the section only you are removing. Okay, that is eclipse. Just continue. Article 13(2) prohibits the state to make any law. Article 13(2) prohibits the state to make any law which takes away takes away takes away the fundamental rights conferred by Part 3 of the Constitution. The fundamental rights conferred by Part 3 of the Constitution. Part 3 of the Constitution. So, any act or law you are creating right now, and that law and act is conflicting with any of the fundamental right, the act which is created by the government, which is conflicting with the fundamental right, only will be deleted. Fundamental right will remain. So, this is the ideology. No law which can able to create by the state, which is violating or conflict with the fundamental right, will the law need to remove it, not the fundamental right. Fundamental right will remain as a same. Okay. For your understanding, next point you can write it down. The doctrine of waiver, W-A-I-V-E-R, the doctrine of waiver does not apply in Part 3 of the Constitution. Because these rights have been put, in the Constitution. These rights have been put, put in the Constitution, not merely, M-E-R-E-L-Y, not merely for the benefit of the individuals, but as a matter of public policy, for the benefit of general public, for the benefit of general public. What is doctrine of waiver? Loan waiver, you know now. The moment new government comes, for example, when the moment Mr. Yogi Adityanath became the Chief Minister of UP, so what he did it, the moment he came, he gave 1 lakh crore rupees a free waiver to all agriculturists who got loan from the government. Completely, with one signature, he removed all the loans of all the agriculture in UP. So you are simply deleting the provision that you don't need to repay the money. That is an ideology. Like this manner, citizens or any body or any authority don't have the authority to make a waiver for fundamental right. The fundamental rights are the one it is inserted inside the Constitution. The fundamental rights are the essential part of the Constitution. The fundamental rights is giving the democratical values and ethos. Citizens don't have the right, okay, I don't want right to speech, you please take it. Citizens cannot able to do that one. The government also cannot able to do that one. No, I won't allow you to speak in an ordinary situation. If it is an emergency and extraordinary situation, government can able to put reasonable restriction. But in an ordinary situation, government cannot able to touch your fundamental right. Same way, people also cannot voluntarily waive their own fundamental right in favor of government. Both the things are available in this category of Article 13. Okay, so this is the way we are defining the ideology of Article 13. That is, one is talking about, two is talking about, two ideologies regarding what is state and how the way a constitution is inconsistent with the fundamental right, a law is inconsistent with the fundamental right, if it is a pre-constitutional law or post-constitutional law. So this is the way we are giving the meaning to the Article 13. Okay, any question, any doubt you are having herein? So the one question one person asked in, that unwritten constitution. What is unwritten constitution? Written constitution in the sense that they will write each and every provision starting from 1 to 395 article. India, if I am taking like that, but numbers will be there. But in an unwritten constitution, it is not the meaning that they won't have any document to read. Unwritten in the sense that they won't codified with the help of legal body. Indian constitution written, it is not like that they write it in their hand and give it to the people. They gave every provision, they typed it, they made a constitution starting from 1 to 9, 1 to 100, 1 to 500, something like that, in a very cleared manner. So it is a written constitution. But unwritten constitution will have the document, but not on the basis of the codification of the parliament, by the way of norm, by the way of values and customs. Certain principles will be codified in the society itself. The society will practice certain things. Based on that, people will have their own constitution. That is unwritten constitution. Best example, if you are seeing United Kingdom, in United Kingdom, laws are existing. They are also having a legal document. But the legal document, the best example, in 1215, the Magna Carta announced by the Crown is considered as the most important document so far till now in this world related to fundamental right. Those fundamental right related Magna Carta, 1215, the Queen announced, later came to United States of America and converted itself in the name of Bill of Rights. And that Bill of Rights from later came into India and converted into the fundamental rights. So the origin of the fundamental rights is there in UK. A Magna Carta. Magna Carta is a legal document. It is written and it is typed. It is printed in every manner. But what? They don't need to codify like the way Indian Constitution enacted by the people, and finally Constitution gave its approval, and finally it codified in a proper manner. It's authenticated in a proper manner and enacted by the Constitution and came into force in Constitution. In that manner only we will say that that is written. Unwritten Constitution also they will have legal provision typed in manner of Xerox copy or printed copy or something like that, but not codified with the help of the parliament of that country. That is why it is called as unwritten. This is called as written. Unwritten documents will be there. Unwritten documents will be there. You have to practice by the way of practice. But here everything is written. It is a document also written. You have to follow those things not by practices. It is strictly by the rule you have to follow. This is the basic difference between a written constitution and unwritten constitution. Okay, good. One point you can note it down additionally, because we are going to discuss some more serious points. So you need to know the basics. The next point for general idea, the meaning of judicial review. Is the power of court, C-O-U-R-T-S, court, to pronounce upon, the power of the court to pronounce upon, P-R-O-N-O-U-N-C, pronounce upon the constitutionality the constitutionality of legislative acts. The constitutionality of legislative acts and the power to refuse and the power to refuse to enforce unconstitutional laws. Okay. Where the ideology of constitutional review we are getting in India? Through which article? Somebody also messaged me here. Article 32 and 226. They are saying, nah, but that is a wrong. It's idea. Okay, correct only. But it is not exactly constitutional review. That is writ jurisdiction. While you are going to appeal before the court, you are having the procedural aspect, 32 and 226. But where exactly the idea of constitutional review is happening in Article 13? Next point, you can note it down. In our Indian Constitution contains CONTINS, contain express, EXPRESS, express and detailed provisions. Express and detailed provisions for judicial review. Express and detailed provisions of judicial review of legislation. In Article 13. Article 13 under Part 3. Article 13 under Part 3. And the power of judicial review is part of part of the basic structure of the Constitution. So, the basic structure of the Constitution, so it cannot be damaged. By Article 368. What is Article 368? Amendment procedure, no? Amending the Constitution, changing the Constitution. So, Article 368. Within bracket, if you want, you can write down amendment procedure. Yes, it is the correct only. Every law is written in unwritten Constitution. What are the laws they are making? It will be go for a written format, printed format only. They will also get the approval like the Parliament of United Kingdom. So, King need to be signed for every law. Counter sign also the minister need to give. This is the difference between Indian laws, and in India, Parliament will pass and King only need to give his, President need to give his signature. But in UK, after Parliament passing the law, the King will give, and immediately the minister also need to sign. The counter sign of King and minister will be there. If anything goes wrong, you should not damage the image of King. Only the minister will take the responsibility individually. That is the point is there. That is why in UK, laws are existing, laws are existing, but that laws are not considered as a codified one through the legal procedures. So, we are saying that there is an unwritten constitution, unwritten laws. Okay, good. Now I think you understand the meaning of judicial review. Okay, now judicial review can able to applicable through 32 and 226. Judicial review can able to give some kind of legal validation through 13(1)(3). Okay. Now we are entering into the most important provision, right to equality, Article 14 to 18. The right to equality, Article 14 to 18. Article 14 states that STATES states that the states shall not deny, states that the state shall not deny, the state shall not deny to any person, the state shall not deny to any person equality before law, any person equality before law or equal protection of law, equality before law and equal protection of law within the territory of India, within the territory of India, within the territory of India. Here equality before law here the equality before law is of English origin. The equality before law is of English origin and the equal protection of law and the equal protection of law is taken from the American Constitution. And both equality before law and equal protection of law, both are trying to establish, both are trying to establish within quotation equality of status. Both are trying to establish equality of status within quotation underline mentioned in mentioned, mentioned in equality of status mentioned in the preamble of the Constitution, the preamble of the Constitution. Okay, good. What do you understand about equality before law and equal protection of law?
Like it should be equal, applicable and equal to all.
Okay, that is. No, both are similar only, equality of law and equal protection of law. If I am saying that equal law, you all are equal before law. Okay, you all are equal before law in the class. No one is above the law. What is the sense? That means someone is above the law, someone is below the law. I want to bring you all equal. That is why I am bringing the concept of equality before law. No one is above the law, no one is below the law. Tomorrow onwards, all are equal. That means someone is acting above the law, someone is always below the law. I want to bring both the people equally, so I am giving. So it is a negative concept. So negativity is existing, someone is below the law, someone always violates the law, because where it originates in United Kingdom, the royal bloods are existing, the nobilities are existing. So while trying to discuss about the nobility, noble people, the royal families are above the law and common civilians are below the law. I want to bring common people and royal family equal among each other. It not always. Sometimes the royal will always act like a royal, common will always act like an ordinary person. Negativity is there. But as a state, what I am saying that I am not bringing someone here or I am not trying to uplift someone. I want to enforce that as a government, I will protect you equally. You are the last person. You are the weaker section of the society. You are the nobility. I will also protect you the same way I will also protect him. A very, very positive concept. I am treating everyone equally. It is a positive concept. I will make you all equal, which means there may be a possibility you may also fail as a government. So the inequality will exist in right to equality, but in equal protection, it is a moral and legal duty of the government to protect every citizen inside the land equally. It is completely a positive idea. So in mains examination, while interpreting, you have to write like this. Okay, good. Continue. While discussing about Article 14, the law may be applicable not in an uniform manner, not in an uniform manner. Because a state may be divided into several geographical regions. The state may be divided into several geographical regions, and a law may be applicable. A law may be applicable to one. A law may be applicable to one and not to other. The law may be applicable to one and not to other, depending on the particular circumstances. Depending on the particular circumstances. But we should not consider a monopoly, M-O-N-O-P-O-L-Y, a monopoly created by the state. We should not consider the monopoly created by the state in its favor violate Article 14. Violate Article 14. So government is trying to bring equality among all, but while doing so, we are having some consideration that in terms of monopoly of business, in terms of monopoly, in terms of trade, the government will have something in its own hand. Here right to equality is not there. So for example, atomic energy, you take it. Right to equality is existing in atomic energy? No. Only the government can able to do anything inside atomic area. But if you are going to public transport system, a private, a public, anyone can able to use Uber if you want to see that, a private sector. The government, Delhi Metro Corporation is the PSU. So private people also there, the government people also there, everyone is also here. That is an ideology. But in the name of monopoly, you are thinking that state is not bringing equality. That is totally wrong, because to a state can able to also create some kind of inequality by the way of monopoly. It is very, very clearly mentioned in Babu Rao versus Bombay case in 1954, the Supreme Court very clearly mentioned that no need of cases. You just keep it in mind that the Bombay case, the Supreme Court in 1954 very clearly said that the court, the government, the state can able to create some kind of monopoly in terms of business and trade and other things. It is not considered as violating the principle of right to equality in terms of security arrangement in the country, space technology, atomic technology, railways till now is coming exclusively in the hands of government only, not private. Here saying that no, Ambani want to start his own railway station and railways. He can't able to ask, right to equality is violated here. Government will put restriction here. Okay? Next point for your understanding. Rule of law is a basic principle which will always strengthen. Rule of law is a basic principle which will always strengthen the idea of equality. The idea of equality. Always strengthen the basic principle, the idea of equality. But rule of law means, according to Deicy, D-E-I-C-Y, according to Deicy, first point A, no arbitrary authority. No arbitrary authority. No arbitrary authority. B, equal protection of law. Equal protection of law. And C, while discussing about the source of constitution, the conflict between collectivism versus individualism. Collectivism versus VS versus individualism. Will always bring right to equality. Will always bring right to equality. In India, the first two conditions of rule of law is exist. In India, the first two conditions of rule of law is existing. In USA, all these three conditions are existing. All these three conditions are existing. All these three conditions are existing to make their fundamental right, to make their fundamental rights as a absolute one, as absolute one, as a absolute one. Article 15, next point. Article 15, next point. Article 15(1) states that the state shall not to discriminate, the state shall not to discriminate against a citizen, the state shall not discriminate against a citizen on grounds only of religion, on grounds only of religion, comma race, religion, comma race, comma caste, comma sex or place of birth. Religion, race, caste, sex or place of birth. (15)(2) prohibits a citizen, 15(2) prohibit the citizen and state, it prohibits both citizen and state from making such discrimination, from making such discrimination. Prohibit states as well as citizens from making such discrimination with regards to access to shops, access, ACCES, access to shop, comma hotels and public places, etc. Shops, hotels, public places, well, tank, road, everywhere, public places, everywhere, etc. The main purpose is here discrimination in terms of untouchability is also existing. To handle this untouchability, 15(2), you need to always connect. When I am taking about Article 17, I will talk about untouchability. So you keep it in your mind. There is another article is also there regarding abolition of untouchability, that is 15(2). Suppose if I am talking about the ideology of judicial review, I will say 32 and 226. But apart from this, Article 13 is also talking about the idea of this writs as well as judicial review. 32 will also talk about judicial review, 13 also will talk about judicial review. Next point, 15C or 15(3), 15 within bracket 3 or 15 within C, empowers state. Now I am going to make some discrimination. It is against discrimination, 15, but within that one I am going to make discrimination. Article 15(3) empowers states to make special provision. To make special provision. That way. Then why the discrimination based on reservation for job in education? I am going to discuss with the help of 15(3). Okay. Empowers state to make special provision for the protection of women and children. For the protection of women and children. Sometime we will switch it off. After some time we will on. 15.3 empowers state to make special provision for the protection of women and children. Okay, right to equality is there everywhere. You are also writing a UPSC and I am also writing UPSC, for example. And while applying your application, you are giving any paisa to the UPSC. You are downloading the application simply in the internet and you are applying and send it. Okay, everything is over. But if you are a male, you need to buy 100 rupees money order. One stamp is there. So you have to buy the postal order and you have to affix with the postal order and money order number while you are going to apply for UPSC. So you are being you are freely allowed to write the examination as a woman, and I am permitted to write the examination only after paying 100 rupees to the UPSC via postal stamp or postal order, etc., etc. What kind of equality? I am thinking that women are the weakest section, children are the weakest section. We can't be able to treat them equally with the male and female. To safeguard women, to giving extra thing to women, I am giving some exemption here. A positive discrimination. It is not a negative discrimination. Last point, I will answer this question for discrimination on the basis of education. The last point. Fourth, 15/4 within bracket 4. 15 within bracket 4. Added in 1951. Added in 1951. Which added in, it is not original constitution, later only they added in 1951, which enables states, which enables the state to make special provisions, for the protection of, to make the special provision for the protection of the interest of, backward classes of citizens. Backward classes of citizens. Which enable the state to make special provision for the protection of interests of the, we are trying to bring equality among all. That is an ideology in this category of 15. But we are going to, the state is creating a positive discrimination in favor of women. The state is making a positive discrimination in favor of backward classes. The reason is that, why does that equal protection of law, what does it, okay, the discrimination based on the reservation on job, education and other various ideologies. The simple ideology is that at the time of making of the constitution, the government felt that, the founding fathers felt that there are more than 50% of the people in the society are coming into the category of backward classes. Those backward classes were as in the backward position more than 100-200 years. So we can't able to make them to come into the equality in ordinary manner. So if you want to put some extraordinary effort, so you can able to make them. So for this purpose, like some kind of reservation or some kind of reservation for the weakest section in the name of women as well as scheduled caste and scheduled tribe came into exist. And initially they said that it is for the particular fixed period only. And later we will do the revision. But what happened? The things went in a different manner and the reservation became the vote banking politics. So they keep on adding and adding and extending and it is keep on going on. Okay, good. And so what does equal protection of law? Equal protection of law is nothing but in equality before law, we are saying that we are treating all equally by the way of bringing the person who is above the law or bringing the person who is below the law, both in a status, equal protection, equality of law. But in equal protection of law, what is the main agenda of the government? Why we are having government? The government is the one who need to take care of the basic things. The government is the one who need to take care of the security of the country. The government is the one who need to take care of the individual things and individual rights. That is the most important thing. So in this category, I am having some kind of problem that some people are not protected well. Some people are having some kind of difficulty in the name of exploitation and other various ideology, in the name of bonded labor, in the name of other economical, they don't have the economical freedom and they don't have other kind of freedom. So in order to provide your own right, in order to provide your own liberty. That is the essential part of the Constitution. Fundamental rights want to provide rights and liberty to the people. But your rights and liberty is not properly coming to you. So I want to give you a right. I want to protect your right. I want to protect your liberty because you are a weaker section. You don't have the guts to ask those things. So on behalf of you, the government is protecting all. That is a very positive concept. We are saying that the protection in the sense that giving rights and liberty to the individual is an ideology of protection. Okay. Next one, Article 15.2, Article 15.3 and 15.4, these are the very ideologies. If I want, I will give the explanation. The first part, 15.1, it's talking about states not to discriminate against a citizen on the grounds only of religion, race. This is the common ideology. In the name of religion, race, caste, sex, place of birth, the government should not discriminate anyone. You may be a minority, you may be a majority. Government should not treat them unequally, one idea. But while going to the second category, the 15.2 is very specifically talk about untouchability. Because before certain times, the government treated, the British government treated Indians as a totally unequal manner. The Indians are not permitted to hold certain things. The Indians are not permitted to access common places along with the British government and British people, and Europeans are always above the law and Indians are always below the law, and right to equality is not properly given to them. And already I told one class that dogs and Indians should not allowed to go into common places like public restaurant and other various places. So the government, once it got independence, they want to eliminate these kind of discrimination inside India also, so they brought 15.2. But while going to discuss about the discrimination, they will also willfully made some kind of discrimination in order to protect women and children and the weaker section of the society. That is a case also exists here via 15.3 and 15.4. Okay. If positive discrimination violates a fundamental right, is it justiciable? If it is violating fundamental right, that is why that is positive discrimination. You understand? Discrimination should not. But I am bringing a positive discrimination here because I want to bring women equally with the male. I want to bring children equally with all. I want to bring weaker section of the society equally with all. That is the why willfully government is doing that kind of activity. But there is a common ideology. The judicial review is applicable right now in every cases. The Kesavananda Bharati case very clearly mentioned about a particular date of 24th of August 1973. On the basis of that, they put a demarcation here. Anything happen inside and after that. Anything after and before. If any law made inside India after 1973, if we are keeping inside the 9th schedule of the Constitution, then that law won't be go for a pass. Previously, that was an ideology. Any law you are creating and keep it inside 9th schedule, the 9th schedule, judiciary won't go and review the matter. But Supreme Court gave a very clear statement. The law which made after 1973, after Kesavananda Bharati case, whatever you are keeping inside 9th schedule, judiciary will come and scrutinize everything. But the law which you have created before 73 and you are keeping inside the 9th schedule, judiciary won't do the judicial scrutiny. This is a common ideology right now. Based on that, anything which is happening after 73, judicial review will become. While discussing about any similarity between judicial activism and unwritten constitution, judicial activism is an ideology on the basis of the principles of due process of law. It is not unwritten or written. Unwritten constitution is also having certain things in the name of procedure established by law and the due process of law. That is an ideology we need to compare with. The judicial activism is nothing but if everything is followed on the basis of rules and regulation according to the prescribed format, that review. So 13 is there, 32 is there. Both will help the people to go for review. But if you are going to another area, judicial activism, They are going beyond the rules and regulation to see the circumstances, then it is considered as a category of judicial activism. But in one way we can say that unwritten constitution is also having a norms and values and customs, but we can able to compare it. There is no issue regarding this comparison, but the most important thing is that there is always a procedure to follow. Even activism is also having some kind of limitation, and review is also having certain limitation, and judicial outreach normally accepted and accepted by the court of law. Then court will always try to overcorrect their mistake via. Okay. Why 1978 is a base? Actually, that the day the government, the court gave the Kesavananda Bharati case, no?
So what was that case?
On the Kesavananda Bharati case is talked about some basic features. In 1960s, Berbari, and after that Golaknath case. In Golaknath case, Supreme Court said that the preamble is not part of the constitution. So no need to worry about preamble. If you want, you take a eraser and erase it, rewrite on your own way. But later the Supreme Court of India gave a proper guideline regarding what is basic structure. First time, what is the constitution and what is the ideology of interpretation and what is the principles inside preamble and how the way you can able to amend the constitution provision in the name of fundamental right. Everything in a very, very clear manner. First time mentioned in Kesavananda Bharati case, and the verdict came in 1973. So they kept the year 1973 as the base for judiciary, that any law, any verdict before that, I won't touch anything. You can keep it in 9th schedule. Judicial scrutiny won't be there. But any law which created after 1973, because now the guidelines are very clear according to Kesavananda Bharati case. If you are trying to do some kind of mistake, before committing mistake, see the Kesavananda Bharati case guideline and try to produce any kind of law or verdict or something like that. So now the guidelines are Kesavananda Bharati case. Any law which is created inside India after 1973 will be completely under the scrutiny of judiciary. Judicial scrutiny, judicial review will be applicable only after 1973 if you are keeping any law inside 9th schedule. Otherwise, all laws starting from 1773 to till now will come under judicial scrutiny. There is no doubt in that one. If the government don't want to go for the scrutiny, so they will avoid certain things. They will take some law and keep it inside 9th schedule. 9th schedule concept is whatever the laws inside 9th schedule, judicial review won't be there. That is a logic they created. But in Kesavananda Bharati case created a milestone that any law which created after 1973 definitely will go for judicial scrutiny, even though it is inserted inside 9th schedule. That is the way they fix the matter. Okay, understood now? Good. Okay. Article 16. No need to much explain about this positive discrimination in terms of women and children and backward classes. That will create a lot of controversy in terms of the Mandal Commission and other various processes. So generally UPSC also won't touch those areas. Sensitive areas normally nobody will ask. Okay. 16 article. Equality of opportunity in public employment. (16.1) also talking about the same, equality of opportunity in public employment, equality of opportunity in public employment. Okay, and write it down below. No citizen can be discriminate. No citizen can be discriminate. No citizen can be discriminate against, no citizen can be discriminated against. It is stated that pre-constitutional law will be void, but it is inserted in 9th schedule. Then in respect of, if it is inserted in 9th schedule, then okay. No. Here the ideologies are after independence, after 1950s. Okay, so you are making laws in 51, 52, 53 like this manner. So whatever the law you have created from at the time of 26th January 1950 onwards to till 2019, for example, the deadline is 1973. So this is the case. From 50 to 73, what are the laws you made it? You can keep it inside 9th schedule. If you don't want to go for government scrutiny, judicial scrutiny, if you don't want, it's not necessary you have to keep all the laws. The law which the parliament and government is executive thinking that it should not go to the government scrutiny, but judicial scrutiny, then they will keep it in 9th schedule. Here also from 73 to 2019, you can keep it, but the condition is that after 73, any law you have created, court is having ultimate authority in the name of judicial review, even though if it is kept under judicial review. That is the only demarcation we are making with the help of 73. Okay. So here strictly judiciary won't interfere in 9th schedule. After 73, it is up to the mood of the judiciary. Some cases they will say, okay, I don't want to see. And some other cases judiciary will say, even though you keep it inside 9th schedule, I want to see, then the government need to show that one. That is an ideology in 9th schedule after this 1973 demarcation of Kesavananda Bharati case. There is no ideology in the name of pre-constitutional and post-constitutional. Wherever the pre-constitutional laws are there, pre-constitutional, till after 1950 to 1998, this is a post-constitutional law. Okay, whenever the pre-constitutional laws are violating the basic principles of fundamental right, that is considered null and void only. Okay, whether it is here or there, it is not like that. Any law, pre-constitutional law, which is violating the principles of fundamental right, that is null and void. That's all. There is no distinction in terms of 9th schedule or post-constitutional and pre-constitutional. There is no connection in that one. All laws which is created before 1950, it will remain in India, no doubt that, but when it is conflicting with the fundamental right, I will make it null and void. That's the only case. Okay. What was the last point?
No citizen can be discriminated
Against or be ineligible for any employment, or office under the state on grounds only, of religion, race, caste, sex, religion, race, caste, sex. Additionally, I am adding some two provision. Descent, 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 comma, place of birth or residence. Place of birth or resident. Place of birth or resident. What is the difference between 15 and 16? What are the additional word you added? You just see and underline those words in 16. While making discrimination on the basis of 15, you mention about religion, race, caste, sex or place of birth. In 16, what are the words you added additionally? Decent and residence. So this word you underline, because if this word, if it is in 15 and they will simply write, they will give everything correctly, but those word will be additionally there in 15. So that entire 15 article is wrong in examination. Okay, so you just keep it down this point, that if the descent or place of birth or resident. So in the previous case I said place of birth is there for article 15 and 16, no doubt in that one, but the residence and descent is not there. We are comparing with the 16, but suppose they will give 15th article and additionally they will also add descent and residence. And after seeing this one, you forget about this is the provision normally exists in 16 but not in 15, but other provisions are the same in 15. You will write all are correct, but if the word resident or the word descent, if it is there in 15 in examination, the entire statement is wrong. The word resident and descent should be only in 16, not in 15 or 18 or something like that. So that is the distinction you need to make here very clearly. So that is why I am asking you to underline the word descent or resident. It is only in article 16. Okay, next point. Article 16(3), 1 and 2 we discussed so far. Article 16(3), please repeat the beginning again. Okay. While discussing about Article 16, the heading is Equality of Opportunity in Public Employment, Common Ideology. In that Article 16(1) and 16(2) is talking about the equality of opportunity to all citizens in the matter of appointment, 16(1). Okay, and 16(2) is talking about no citizen can be discriminated against or be ineligible for employment or office on the grounds of religion, race, caste, sex, descent, place of birth or residence. Okay, so this is the case. Now come back to 16(3). It empowers the Parliament to make a law. It empowers the Parliament to make a law. It empowers the Parliament to make a law prescribing residence within a state, as a qualification, for appointment to any government post. Okay, residents. Some days before, Maharashtra government passed some kind of act that in Maratha will get some kind of special reservation in Mumbai in terms of employment opportunity. But if you are seeing that Article 371D and E, exactly if you are seeing that Article 371D and E in terms of educational schooling and in terms of reservation in terms of some government postings in E and educational institution in D, Telangana area, Telangana people can be able to only admitted in educational institution in Telangana, not outsiders. There is a special quota reservation for Telangana people inside Telangana region with the help of 371D. With the help of 371E, in terms of employment opportunity in Group C and D category, non-gazetted officer post inside Telangana region only will be given to Telangana people, not outsiders. It is mentioned in Article 371D and E. This is the area we can able to mention with the help of a principles of sons of soils. Maharashtra for Marathavadas, a kind of sons of soil. Karnataka for Kannadigas, Punjab for Punjabis, and Tamil Nadu is for Tamil Nadu people only. Like this manner, the sons of soil ideology will come, but only in the area of Constitution 371D, educational institution in all the Telangana region will be given to Telangana people alone, 50% reservation or something like that. And a employment opportunity, Group and C D post only will be Telangana people only, not others. It is mentioned in Article 3D and E. But now Telangana becomes a state in Andhra, separated from Andhra. So I think these provisions won't be applicable here right now. Okay. Next part. 16(4). Article 16(4). Reservation of post. Short term you can write it. Don't write everything. Don't waste your time. Reservation of post in government job. 16(4). Reservation of post in government job in favor of backward class of the citizens, which in the opinion of state, is not adequately ADEQUATELY, is not adequately represented in the state services. Yesterday, Tirupati Balaji temple has denied a non-Hindu workers there, as decided by the ruling government there and backed up by the BJP. What kind of violation? What does this mean? There is an ideology existing everywhere. In Waqf Wariyam will appoint Muslims only in all the Waqf board and all the mosque and other areas. And in Christian charity accounts and charity management areas, Christians only will be appointed. And in Parsi charities and Parsi trust and endowment, Parsi based ideology, minority institution, their minority only will be applicable. But there is an ideology regarding the Hindu temples and Hindu endowment. There is no clear understanding, because we want to only strengthen the minority academy. So very specifically mention about the others are not permitted. While going for the majority, we simply left it because majority don't have under any threat according to the constitutional makers. Only minorities are in the fear. So I want to comfort them. I want to make them, because there should be no Pakistan again in India. In the name of Christians only, Muslims only, Jains only, these kind of groups should not develop. Let them join in the assimilation. So we gave who are the weaker people, for them only we will give reservation. It is not the sense that general people don't have any right. So that is a common case that the non-Hindu workers are denied to enter into the area, because now the ideologies are coming in a very, very direct manner. If in Christian areas and Christian institution and Christian academy, Christians only, and churches, Christians only, and Waqf Wariyam only Muslims, it is very clearly mentioned about. But if you are seeing that a state like Tamil Nadu, there the Hindu endowment area, non-Hindus are not allowed to write examination. If you want to, in State Public Service Commission, anyone can able to write. But there is another post, Group 1, Group 2 officers are there for the Hindu Endowment Board. A State Public Service Commission will conduct the examination separately. There, non-Hindus are not permitted to write the examination, because Hindu endowment means the Hindu person, the person who is following the Hindu ideology can able to only enforce the endowment of Hindu ideologies. So in that logic, the exemption has done by the discrimination done by the Tamil Nadu government. But these are the ideologies. The Tirupati temple and the temple management, there it is some kind of what we say that sometimes we will say that it's a private administration and private affairs, and some people who is in charge of the Tirupati Devasthana board is a non-Hindu. The chairman of the entire board is a non-Hindu, a converted Christian. In the name he is Hindu, but he is practicing Christianity. So based on that, there was an ideology that the way the Jagan Mohan government, and purely that is a politics, there is no connection with the fundamental right. In terms of vote banking politics, secularism sometimes will be under strain. In terms of vote banking politics, casteism will also predominate in some area. In terms of vote banking politics, rules and regulations, divide and rule things will be happen in that. But if you are seeing that the temple management and temple endowment board can able to decide about the rules and regulations, there if it is a minority or majority, the government normally won't interfere in those activities. Okay, good. Continue. 16(4) in terms of, okay, 16(4) had done it. Okay. At next point you can write it down. Through 77th Constitutional Amendment Act. Through 77th Constitutional Amendment Act, 1995. (16(4)(a) was added in the Constitution through 77th Constitutional Amendment Act 1995. 16(4)(a) was added into the Constitution, which empowers the state to make any provisions for reservations in matters of promotions for scheduled caste and scheduled tribes, in the matters of promotion for scheduled caste and scheduled tribes. Yes, the board of temple comes under state definition. Yes, that is the thing. The state government will decide about. The endowment boards will come under the administration of state authority, state government. So the state will decide according to their own. Okay. In the matters of promotion for SC, STs, full stop. So here the case is that without compromising the quality as well as without compromising the ideology of the competence among each other, the government of India added 16(4) inside the Constitution of India in order to give some kind of provisions to the scheduled caste and scheduled tribe people inside the category of reservation, empowers them. Okay. So these are the ideology. This is another controversial part everywhere. People will say that every part there will be a counter argument. So if you enter into the counter argument, the class will go in a very debatable manner. So according to the UPSC syllabus, we have to very strictly confine with them. So as a student, you just know what are the provisions are existing, because why we are adding constitution into a syllabus, because as a future district collector and district management authority, you need to know what is the provisions are existing in the constitution. So now you say, what is 61 is saying, 1 and 2 is talking about? In a very simple manner, equality of opportunity in public employment, but the state can make some kind of discrimination except in the category of religion, race, caste, sex, descent and place of birth or residence. Okay. But if you are going to further 16(3), in the name of residence, state can able to make some kind of reservation. And in 16(4), in the name of reservation, we can able to give some reservation to certain weaker section of the society. In the particularly in 16(4)(a), in terms of promotion also, they can able to get a reservation. That part challenged in so many ways. If you are going for reservation in promotion, then it may affect the competence and the competitive nature of administration. People ask so many things, but I don't know, in 1995 the government inserted these provisions, then it happened. Okay, last one, 16(5). Article 16(5) saves a law I think his question yesterday, Tirupati Balaji temple, na, we can able to give some example. Action 16(5) saves a law from the operation of class 1 and 2, which provides for the incumbent, INCUMBENT, the incumbent of any office a religious qualification for appointment. Article 16(5) saves a law from the operation of class 1 and 2 which provides for the incumbent of any office a religious qualification for appointment. So now you have some satisfaction that how the way the things are happening. In a very clear manner, Article 16(5) saves a law. Any law has created by the government through 16(5) and it is violating the ideology of Article 16(1) and 2. We can able to say that through 1 and 2, the government cannot, no citizens can be discriminated against law on the basis of the religion, race, caste, section things. But in terms of appointment, the government makes some kind of discrimination. On the basis of that, only one religious person can able to enter into. If you are going to Gurudwaras, throughout India, lot of Gurudwaras are existing. Who can able to appoint inside Gurudwara to manage? There is a separate board is there. Only Sikh community is the one who is managing. No Muslim, no Christian, no Hindu or no other person are allowed to do that one. So this is the way they can able to manage their rituality in a proper manner. So 16(5) is very clearly saying that, okay, for the maintenance of religious things, you normally will go for these kind of appointments. While discussing about this idea, there are one simple logic you need to remember, that is carry forward law. In terms of reservation in 16(4) and in terms of reservation very particularly in promotion 16(4)(a), while doing so, it should not violate the principles of 50% and 50%. So general community can able to get 50 and our backward community can able to get another 50. So this is the logic we are practicing in India, but sometime what will happen in this 50-50 will going to some vacancies here won't get fulfilled properly, 50% will get over, here only 45% will be get filled in backward area and 5% of the seats will remain without filling. And if you are going to the next year and again you are going to keep 50-50 next year, but what about these 5%? It will go again to the general community as well as 50-50 only, 2.5 for general and 2.5 for backward community. So it will create some kind of indiscrimination or unjust. So what they are saying that next year, for example, 100 seats are there next year. In that 100 seat plus that last year 5% seat. So in that 100 only we will go for 50 and 50 and within this 5% will be there. Practically 55, but that is last year, so they won't dilute into the general category. So this is the way the carry forward things are happening in India, but only few exceptions are there. Constitutionally it is permitted, court also permitted. The state like Tamil Nadu, Karnataka and Rajasthan, These are the three important states who usually go for more than 50%. Tamil Nadu is giving reservation for the backward community for 69%. Why it is permitted? Their entire population, more than 90% of the people are backward community. Only 3 to 5% only general community. For this 3 to 5, they are giving 31%. For this 90 to 95%, they are giving 69%. So according to the government and the court of law, it is acceptable things. For 5% of the general community, you are giving 31% reservation. General community is also happy. And for 95% of the population, you are giving only 69% reservation. So both also, they also satisfied because from 50, they moved into 69. Karnataka is also giving more than 50%. Other states are also, like Rajasthan is also giving more than 50%. These are the only states are permitted to keep more than 50% reservation for backward community due to their population, more population of backward community. All other states strictly need to follow 50% in general 50, open competition, and backward class 50. There is no changes in the 50-50 ratio. This is the way the court is giving in the name of carry forward rule as well as the general quota in terms of reservation 50-50%. One additional point, you can write it down. The difference between Article 15 and 16. Next, final point you can write down. The difference between Article 15 and 16. Article 16 guarantees against, Article 16 is a guarantees against discrimination. 16 guarantees against discrimination only in, underline, discrimination only in employment and appointment. Discrimination only in employment and appointment. In last 10 years vacancy be added to reserved quota. The last 10-year vacancy to be added into reserved quota. That means if you are having last 10-year vacancy, for example, it is not filled, so it will be also diluted into the category of 50-50. Without altering 50-50, there is no, even the carry forward rule should not alter the principle of 50-50. 50-50 remain. So you don't get too much inside this area in terms of UPSC point of view. 50-50 is 50-50 is a common idea. Okay, then you can take this one. 50-50 is the common ideology. Okay, the carry forward rule or the one need to be kept separately. So if I am adding again 50-50, there may be a possibility in order to suppress the backward community, the government may say that every year there is a backlog of backward community vacancy, and next year they may add it into the general community. For avoiding those things, the 50-50 remain always within the bracket. The carry forward rules will be applicable. That is separate. This 50-50 is separate. So whatever the vacancies are coming for the last year, it need to be keep it separately, and whatever the regular vacancy that will be. But according to the RTA recently revealed that they applied against UPSC. So far the UPSC gave only one time maximum 24% for OBC community, and they never fulfilled 27% from the beginning to till now. This is the way reservation is happening indirectly. That is totally different. That is a controversial part, no need to. Just you remember, 50-50 is a common sense. Within bracket, the carry forward will be there. Carry forward separately, the main 50-50 separately. But we don't know which is carry forward and which is original. That will be decided by the government only. Possibilities are there. Okay, good. Article 16 guarantees against discrimination only in employment and appointment. Article 15 is more general. Article 15 is more general and deals with all cases of discrimination, all cases of discrimination which do not fall under Article 16, which do not fall under Article 16. Okay. 17. Abolition of untouchability. Abolition of untouchability. Abolition of untouchability. What is abolition of untouchability? Okay, that's all. Untouchability is the one not in terms of only in the category of caste or something like that. Untouchability, already I told you, it was existing during the British time onwards. For them, Indians are untouchables. Even if you are going to some part of India, Indians are untouchables in India. Huh?
There is this beach in Goa which is
No,
only.
that is only foreigners, means in order to attract tourism, so we are allowing only foreigners. That is a different, the logic is there. Indians should not touch the property and the people. If you are touching, then fine will be there, penalty will be there. In India, some villages are there. There you can go and watch up to certain limit. Beyond that, no one permitted to enter into. Tribal groups, not all tribal groups. Tribal groups completely restricted. If you are seeing that the Malana village is a very popular village inside Himachal Pradesh, they are saying that they are the descendant of Alexander the Great. Still they are maintaining the greatness. So according to them, Indians are untouchables. So if you are touching them, it is a it's a penalty based offense. They will give minimum 3,000 to 5,000. And
Where are fundamental rights?
your fundamental right won't be exist there inside. For if you want to give complaint against them, first you have to pay 1,000 rupees to the local village council. Then village council will permit them, okay, you now go to the police station and give complaint. Then you take the complaint and come to the police station. It is up to the police will accept it or not. There are some places are existing in India that is totally different. It is not only preserving their cultural things. There are a lot of superstitious ideologies also there. Some 2013 around, there was a case. Then based on that, the problem, if every conditions come in employment, all are allowed. Yes, all are allowed. If 50-50 and 40 conditions come in employment, if 50-50 within bracket 40 comes in employment, what is this? And this is the 10% is an ideology simply carry forward, that will be separate, and the current vacancy again divided into 50-50, and don't consider the 50 and 40, maybe 90% is right now in employment and 50 in right now. That is totally different. So simple ideology, you keep it every year 50-50 we need to give. Other than that, last year vacancies, that will be separately, from which OBC last year vacancy will come separately to OBC. SC's last year vacancy will come to SC's status. ST's last year vacancy will come to ST's. So it will completely different. Don't get confused. If you are adding those things, then OBC and backward class will go beyond the 50%. That is carry forward. That is the way carry forward rules. Last year vacancy will be carry forward to the next year rules. That is different category. Okay, good. Just note it down. Abolition of untouchability, Article 17. The term untouchability, is not defined in our constitution. That is another problem. But it is meant to denote, D-E-N-O-T, denote okay, that is it is meant to denote different practices in Hindu communities, in different parts of India, different practices in Hindu communities in different parts of India as developed through ages, 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 such a long 1st century, 10th century, 14th century, 18th century, like this manner. The first law, second point, the first law was enacted by Parliament. The first law was enacted by the Parliament to punish the practice of untouchability. To punish the practice of untouchability was the Untouchability Offences Act 1955. The Untouchability Offences Act 1955. The Untouchability Offences Act 1955. And it is renamed into Protection of Civil Rights Act, PCR Act, renamed into Protection of Civil Rights Act 1955. Here the most important case is that if the person who belongs to scheduled caste and scheduled tribe, if he is given complaint against his superior in the name of PCR Act, the superior will immediately get arrested without inquiry and no non-bailable warrant against him. So people misuse this provision such a long time. Some people misuse this provision such a long time. It created a lot of issues. Currently in 2019, the Court of Law give a final guidelines that now hereafterward, if you are using PCR Act 1955 against your district collector, for example, that it is not non-bailable warrant. First, the court and government need to appoint a committee to discuss about this matter. If the committee is saying that yes, there is a process, someone is misused the caste line, someone is abused him on the basis of the caste line, if there is a evidence, then committee will recommend to the government and government will tell to the court and court proceedings will be followed. If they find someone misused this provision for protection of himself in the name of PCR Act, then action against will be taken against the person who is using that caste identity. So this is the way some relief has given to the government officials and government authority against this PCR Act 1955. Previously, no more inquiry. The moment you give PCR means immediate action, a strict action in order to abolish death untouchability. But it was misused by so many people in so many ways inside administration, and administrators are having some fear to take action against some people. So now in 2019, the court, the untouchability is no more defined in our Indian constitution. Untouchability is not defined in our Indian constitution. But one thing you can able to add, that the first law enacted by the Parliament in India is Untouchability Offences Act 1955. Untouchability Offences Act 1955. It also renamed in the name of Protection of Civil Rights Act 1955, PCR Act 1955. It also renamed as Protection of Civil Rights Act 1955. But the problem inside this one, some people are misusing this power of PCR Act against the superior and subordinate. So it is creating some administrative deadlock to avoid these things. In 2019, Supreme Court gave a guidelines that PCR Act won't be used immediately against their official. Let the government appoint a committee and they will discuss about everything regarding this one. On the recommendation of the commission, the court will take action. Previously, it was non-bailable warrant. Now they relaxed that provisions also into bailable warrant. So this is the way the recent things happen in 2019 regarding PCR Act 1955. Okay. Article, next point, abolition of titles. Article 18, abolition of titles. It prohibit, Prohibat, it prohibit the state from conferring, it prohibits the state from conferring titles on citizens except military or academic distinction, except military or academic distinction. Military or academic distinction. Okay. For example, sir, some title they are giving Sir, Rao Bahadur, so and so, so and so, so and so. So the person who received knighthood immediately need to call by Sir by everyone in UK and throughout the Commonwealth countries and everywhere. But these kind of titles is bringing some inequality. You showed your loyalty towards British government and they have given this title to you, then how the way I need to call that person as Sir inside India? It is bringing some kind of inequality. So the government created a very clear writing, some Raja Mukhya, Princess, Maharaja, something like that also later came. Everything we abolished. There is no need to call anyone in that name. So what happened right now? Titles you can have, but only on the basis of your academic titles. Doctor, you done PhD and they are awarding doctorate, doctor, and you studied something and you are putting ER, BR, DR, KR, so many new R's right now is coming. You can keep it. But if you are keeping any other title from foreign country as a civil servant, you have to get the permission of president to get the title, one thing. But you should not use the title. But some people are using the Bharat Ratna, Padma Shri, Padma Vibhushan, all the things are there. But if anybody is objected that move, then you should not use as a Bharat Ratna, Bharat Bhushan or something like that. So this is a very clear understanding that you need to keep it in your mind that those kind of things you can utilize it, Bharat Ratna, Bharat Bhushan, but anybody objected, but you should not use those titles. Other than that, military and academic titles, we can use it. This is a very common ideology while discussing about abolition of titles. Okay. The next one, and the most important one, Article 19. Article 19. We are having various rights in the name of Article 19, freedom of right. So I said at the very beginning that you are having certain liberty and right. Based on that liberty, you are expressing yourself freely. Is there any compulsion or any fear you are having in your mind whenever you are having doubt? If you know the subject, you are asking and you are speaking. If you don't know the subject, you are asking me to repeat it again. So we are doing that one. There is no compulsion or there is no fear in your mind that whether I need to ask it or not. Only one thing that is self-disbelief people will have. They will have some doubt, fear in talking in before media or before group of people or something. That is different. So the most important thing, the freedom of speech and expression and assembly and association and movement and settlement inside a particular area in the name of residence, and finally and profession and occupation and trade and business. These are all the ideology. Generally people will say that the freedom rights, right to freedom. So while you are speaking, your speech should not hurt my sentiment. If your speech is hurting my sentiment, then immediately I will put some kind of restriction via Government of India. And at the same time, you can also have something in the name of assembly. But there is a place when your 123 or 144 section is existing inside Jammu Kashmir, there you can't say that I am having a fundamental right in the name of freedom of assemble. So all Jammu Kashmir people can able to assemble and have some kind of meeting. It is not permitted, because when there is an emergency situation or when there is a reasonable restriction, then the Government of India can also be able to suppress your fundamental right. Is the most important thing. Article 19 is giving some kind of meaning to the people. At the same time, Article 19 is also giving some kind of freedom to the government. When there is an emergency, then immediately government will terminate Article 19 via, if it is external emergency or armed rebellion, then immediately the court will do these kind of things. So while discussing about the freedom, this freedom will help you to act in a very free manner in India. This freedom is giving certain right to you as a citizen of India. On basis of this freedom only, you are having every right to act like a human being. That everyone knows that the speaking is the only things the human being is having while comparing with animal. Animal won't speak, but the human being will speak. In general manner, if you want to say that, people will say that animal at least will bark and in order to express themselves. Human being also speaking in order to express themselves. But only humans, only inside the planet, human only will laugh, but other things won't laugh it. But that is also slowly disappearing now in the modern world. Laughter. Nowadays people not at all having on their face. One side you keep it. Because of the pressure they are having in workplaces. Because of the pressure they are having in family. Why you are not a free man. The freedom is not in your mind. The freedom is not in your heart. The freedom is not physically apparent to you. So you are slowly forgetting to smile and you are slowly forgetting to do all kind of activity. So this is another problem in modern era. We will are discussing about the freedom of speech and expression is helping people, but while doing so, some kind of distinction also I am going to give. If you are a parliamentarian, if you are a governor and president of India, the right to equality won't be applicable to you. For example, why I am saying this? The president cannot be able to get arrested in his entire 5-year tenure. But you and me is having the tenure? No. When we are doing some criminal activity and civil cases, immediately the police can take able to action against me. But in terms of president and governor, there is a restriction. In terms of civil cases, in terms of criminal cases, in other cases after getting permission they can proceed. But for the president, for his entire tenure, normally cases won't be applicable against you except the civil cases. One idea. Second, the member of parliament is speaking something inside parliament and I am speaking before the camera. Through the evidence of camera, if I am speaking against Motiji, someone may file against a defamation case against me, but not against the member of parliament who is speaking inside the parliament. Right to equality is there, but some kind of special provision also there for them inside parliament. While doing my own parliamentary duty, I am having freedom to think, freedom to speech, freedom to act like that. So no one can able to get arrested what they are speaking inside India. The best example I can have, I can speak with the help of simple example. When Rahul Gandhi spoke something about the Prime Minister after some rally, in the way he called, the Prime Minister is behind the saris of of the Women Defense Minister, then immediately the National Women's Commission sent a notice to Rahul Gandhi that why you can able to say that a women Prime Minister behind the President is hiding. So a women Defense Minister behind her the President is hiding. Are you trying to deframe the image of women in India? So please explain. They sent a notice. But when the Prime Minister of India spoke something against Renuka Chaudhary, in the concept of popular Surpanaga concept, nothing happened him against him because he spoke individually inside the Parliament of India. Other bodies and court don't have any authority that if a member of Parliament is making any comment while doing his parliamentary duty, no one have the right to ask question to a member of Parliament. Prime Minister is also a member of Parliament. In that case, no case and no notice against the Prime Minister, but Rahul Gandhi spoke outside the Parliament in election rally, then the case against him. So this is the case, the speech and expression, you can be able to speak within the house according to the privileges they are given to the member of Parliament, you can able to. The media is writing something about the parliamentary proceedings. But if it is the normal case media, the contempt of court and contempt of Parliament will be there. But within the house, if we are writing about the proceedings of the house with the help of some kind of the live telecast and other various things, there some kind of exemption will be there. So in this case, the freedom of speech and expression is there, but it is not for equally with all. Member of Parliament is having some extra power and extra jurisdiction inside Parliament, the way what they are speaking and what they are acting and etc. Even right to arrest before 30 days and after 30 days, you can't able to arrest a member of Parliament because the government may arrest a person even before the assembly itself, that not to allow him to enter into the house while participating in no confidence or any kind of motions. So there may be a possibility. So the protection is that a member of Parliament cannot get arrested before and after 30 days of Parliament. So some kind of concession. But for me, anyone can able to come and arrest me immediately for any kind of action, any kind of speech and all those things. And while forming an assembly, the common ideologies regarding assembly, the government anyone can make any kind of assembly, any kind of association, but while going to, when 144, section 144, the curfew is existing, more than 5% cannot be able to walk together inside the road. In other case, 1,000 people can go for walking, no one. But in emergency, a curfew is there, more than 5 persons are not allowed to assemble in a place. This ideology is there. And I am having every right to form my own association. But military persons and security persons and civil servants are not permitted to form their own association. They can form their own welfare association. But civil servant and police people not allowed to form their own union. If all the police and military is going for a strike for 1 week, what will happen? All terrorists in Afghanistan and Pakistan will enter into Delhi. So we should not allow those people to have some ideology in the name of union or association. And apart from this, reside and settle, you can go anywhere and reside, but with the reasonable restriction. If you are trying to enter into the tribal area, the protected area, in order to preserve the culture of the tribal community, we are putting some kind of restrictions. Being an Indian, you can take your vehicle and go to up to Gangtok, the capital of Sikkim. If you want to go beyond Gangtok, you need to get the permission in the name of inner line permit letter. But for the foreigners, that is also not allowed. Foreigners are not allowed beyond Gangtok. Only Indians are permitted after getting the inner line permit letter. Inside Andaman Nicobar, you can't able to go anywhere according to your own way. There is a restriction to preserve the culture of. So movement is there, reside is, you can settle anywhere. But while purchasing property inside Himalaya, inside border areas of northeastern state, you can't able to buy anything. We are only talking about Jammu Kashmir. In Himachal, you can't able to buy anything. In Uttarakhand and the border as a sensitive area, you can't buy anything because government want to secure, government want to protect our borders in a proper manner. Based on that, these ideologies are existing. So these are some common ideology we can able to discuss. Okay. Any question or anything you want to ask? Yeah, thank you. For other people, on online people, I think I will take 2 minutes rest, and after that you can ask any number of questions you want to ask. So 10:30 to 11 I am here, so you can able to ask.